Joining us to break down the impact of FATCA and the impact it may have on people and companies. Michael Silva, partner, DLA Piper law firm, live from New York. And here in Washington, Marylouise Serrato, Executive Director of American Citizens Abroad. And Mary, let me start with you. FATCA, explain to our audience the purpose of this law. Is it to fight money laundering? Is it just to collect more taxes? What's the purpose of the law and who are they targeting?
Well, FATCA was passed as part of the HIRE Act in 2010, and it was passed as a measure to combat tax evasion. ACA believes that the Congress was concerned about Americans who were living domestically but who had unreported offshore accounts, and we believe that indeed was the target of the legislation.
You heard me talk briefly about some of the Americans who are living abroad who may have to worry about losing their bank accounts, for example, or being dropped by their financial institutions. Is that a real concern?
Well, what we're hearing and seeing is sort of a trend pre-FATCA and post-FATCA. Pre-FATCA, ACA never received any reports or rarely received reports of Americans being dropped by their banks or denied banking services. And post-FATCA, we were starting to see increased reportings, and we are continuing to see that. The problem is being experienced worldwide, although there are some areas where it's more acute. Now that FATCA is being implemented, what we're also starting to hear is people who are being allowed to maintain their bank accounts but have to provide their banks with the appropriate documentation to show that they're tax compliant.
As all good disputes, we must talk to a lawyer, and in walks Michael Silva. Good to see you again, by the way, Michael. I'm just going to throw it out there. Do you think this is a fair law?
Well, that's a discussion that was had with Congress a long time ago during the comment period, and that law, as my counterpart commented, became law in 2010 by a vote of bipartisan Congress. And now we're left to contend with the implementation and compliance. My perspective is dealing with entities outside of the United States trying to comply with the new rules to continue to do business in the U.S. And they understand they're being forced to collect information in ways that wasn't required before and to ultimately seek and flush out any U.S. persons that are not reporting in the U.S.
Okay. Now, for the record, I have spoken to other people who may fall under this law, who may have foreign assets, 50,000 or even more possibly overseas. No one's happy about this. No one says, this is a great law. I want to disclose everything I have around the world. Please tax me. You don't hear that from any Americans, and I'm sure you probably don't have any like that as well. But the truth is that isn't this law originally designed to crack down on big tax evaders, not people like you and I who may be working overseas?
Well, there are certain thresholds where they're trying to take a risk-based approach to see where there's the greatest opportunity for tax evasion and to flush out and implement the greater measures which have some burdens in those areas. But there are exceptions, there are exemptions that have been provided, and they have done what they can to ameliorate the burdens of complying with local laws on privacy, data secrecy, and balancing that towards their information requests.
All right,
so
let me bring in Marylouise. You represent Americans from all over the world, outside of the United States, and when they don't like something or they're confused about something, they come to you. What have you heard from them, and what advice are you giving them when they come to you and say, hey, first of all, do I qualify on this? Where do I get help, and what do I do?
Well, again, they come to us when they start to see problems in terms of the banking lockout, and we don't advise individually on individual cases, and we can't tell people individually what they should or shouldn't be doing in terms of tax compliancy in their filing. However, we can give them recommendations on where perhaps they can go to find qualified financial institutions.
They need to seek expert opinion. They need an accountant. I'll tell you, look, they need an accountant, they need a good lawyer, and they need a lot of time to understand this. I mean, because this can be very confusing. I mean, the short time that we're talking about this, I mean, this is difficult to understand, right?
It is, and we do recommend that people seek professional help so that they're competent and know what it is that they need to be doing.
Are they afraid? Are they scared? Do people call you and say, "Look, I'm a taxpayer, I haven't done anything wrong, but this would scare some people," don't you think?
They are concerned. Now, what we're seeing in the reporting to ACA is many of these individuals are concerned about the data exchange and having to sign legal disclaimers releasing the banks from some liabilities in terms of data exchange. So yes, there is concern and a certain level of fear out there over the FATCA legislation.
Michael, I want to bring you back in here. One of the comments I've heard from some of the banks are, look, if I have a client who's a U.S. citizen and he or she is not telling me all the information that I need to know, and I'm the bank and I have the information to know your client information, and I get in trouble for it, I didn't know anything. How far can a government go to hold the financial institutions accountable for something they may or may not even know?
Well, the obligations of a financial institution overseas have been laid out fairly well in the FATCA regulations. There's excruciating detail on what they need to do. It's not simple, but they need to have professional advisors guide them on what categories and classifications their clients will fit. And if they don't fall into a specific exemption, they need to obtain documentary evidence, scrub their accounts of pre-existing clients to determine whether there are any overlooked U.S. taxpayers that have not been appropriately reported on. And going forward, if they rely on the information, but it's later found to be incorrect, they should be fined. If they fail to have relied on forms because they did not obtain a properly completed form and compared it to a website listing all the associated representatives and intermediaries that have something called a GIN, an approved global intermediary identification number, then they will fall short of their obligations and they could be left holding the bag as withholding agent for 30% of the amounts paid out.
Well, I wish we had more time to go into it. As you can probably tell, this is not an easy case to digest. Michael Silva, partner DLA Piper in New York City, I want to thank you for your time helping explain us. And of course, Marylouise Serrato, Executive Director of American Citizens Abroad, helping them, of course, with this complicated task of filling out their taxes and now this whole new form. Thank you.